Good morning, everyone. Today's January 6th, 2022, and we are about to kick off the third year of the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motan in the spring of 2020. Every Thursday, Jean Lawler and I are so happy to host another cutting edge webinar, and we are starting 2022 with a bang. Sarah Agamiri is also on our team in Canada, running the administrative end of things, and we're so happy to have her on the team as well as we begin this third year of encouraging people to contribute to food banks to fight food insecurity worldwide through providing these incredible educational seminars. And today we have an incredible speaker, Phyllis Bernard. Phyllis, Professor Emerita Phyllis Bernard recently retired from nearly 30 years of bringing the real world into the classroom at Oklahoma City University School of Law. The third chapter of Phyllis's life is taking place in Port Angeles, Washington, and in the Pacific Northwest, she is enjoying a deeper synthesis of lessons learned and stories to be told about law, culture, justice, and ethics. Her work in ADR brings a nearly 360-degree national and international view drawn from her roles as corporate director, adjudicator, litigator, business lawyer, administrator, negotiator, mediator, ADR trainer and supervisor, ADR system designer, and evaluator. Phyllis has degrees from Bryn Mawr, from Columbia, from Penn, and I consider her one of my best friends. So Phyllis, we're so happy to have you here. Please tell us a little bit about the food bank to which you would like people to direct contributions if they're in a position to do so. And then on with the presentation. Phyllis Bernard, the floor is yours.
Thank you, Jeff. I appreciate so much your introduction. And I thank you for the opportunity to share a few words about the Port Angeles Food Bank. This food bank serves not only Port Angeles, which is a tiny city, like 23,000 people, but it also serves all of Clallam County, which is much larger in population and basically takes up the Olympic Peninsula of Washington State. Now, our area is absolutely gorgeous. On the slide that you will see there, that has my opening picture, then you'll see on the right there, Purple Mountains. When we get to the first one, yeah. And that is actually pretty much the view that we get just driving to Costco. It's all around us. There's the Olympic National Park. We live around the fringe of it. There's the Hoh rainforest, temperate rainforest here in the United States of America. There are lots of protected marine highways for the orcas, the humpbacks, the blue whales. But truth be told, you can't eat gorgeous scenery. It just doesn't work that way. It doesn't put food on the table. And the timber industry, the fishing industry that used to be the backbone of this economy, they've collapsed, mostly due to advances in technology. And so, to be honest about it, my husband and I have lived fairly privileged lives, and we did not understand until we started adjuncting at our local community college how great the need was amongst families here. So if you enjoy recreating in beautiful, gorgeous areas like this, please think about letting this be your opportunity to give back during the off season. So next slide, please, Sarah. And I want to thank Jeff and Jean and Natalie and Sarah for giving me this opportunity to be able to share a few ideas. There's a special dose, though, of appreciation to Sarah, who will be handling the slides. Electricity on her end is more reliable than it is on my end. Now, The slides that you'll be seeing are background to what I'll be saying. They'll provide some visual constructs for the narrative and try to make sure that I don't go off in full storytelling mode. Okay. Now, just a word in advance. If anybody who knows me and my work from my days in leadership positions in the American Bar Association or the Association of American Law Schools thinks that maybe I've changed my mind about what I espoused concerning ethics and dispute resolution, no, that's not so. Those fundamentals have not changed. It's just that I'm going to talk today about adding something more for resolving disputes that may not be best served when treated solely as a transactional matter where it's just really about money, a one and done. Now, several of my professional homes will be alluded to, but please understand that today I speak for me solely and not for anyone else, not for any other institution. And so also whatever errors that you identify, they're also mine, just mine. Okay, next slide, please. Yeah, if we were to talk about there being a through line for my career, it would definitely be building bridges between law and culture. I suppose that came a little bit naturally because, like many folks whose families are immigrants, my family immigrated from the Caribbean. You're constantly living in at least a couple of worlds. There's the traditional culture, and then there's the Western culture where you make your money. Those are not necessarily the same things. And so we spend most of our life with one foot on one side and the other foot on the other side, and we kind of live as bridge people in the middle there. Now, one of the things that we learn is that when we are trying to use some of those very Western skills, like what I was taught at Wharton, that's not really the end of the story. In years in private practice, in doing mergers and acquisitions, corporate reorganizations, and privatization of public entities, my focus was especially on the employment impacts. What happens to the people when you make these institutional changes? Well, one of the things that we learned is that it doesn't work the way we planned, that long before Harvard Business Review had popularized this little saying with a lot of power behind it. Culture eats strategy for lunch. All of the great legal and financial strategies we might have come up with, boom, it smacks up against the wall when it is time for you to actually implement it, because the norms, the values, the culture of the place, the profession, the skilled work group may often override everything that you had planned in advance. And so for those of us who see the law as the foundation for American life, maybe especially this day, January 6th, is a time for us to reflect on how strong that foundation really is. The legal institutions and the societal norms that we just assumed would always be there, it looks sometimes like they're fracturing. It feels sometimes like they are perhaps slipping away. Now, I want to put to you the proposition. For the last couple of decades, negotiation and mediation increasingly are a party's sole means to resolve a dispute. They're not going to end up in court. Not really. There won't be a trial. and no record would be left behind to explain what was done, why it was done, how it was done. And so this leaves the third party neutral and the attorneys to attempt to do justice without a judge there in the room. Note I said justice as a transitive verb. It's not a race, R-E-S, a thing that can be discovered in the courthouse. Justice is really found in a relationship among people. Next slide, please. Thank you. Now, in many ways, the subjective perception of whether justice was done may rest in the hands of the third party neutral. Mediators may be wary about wading into the deep waters of justice, keeping an eye out for whether something that was done was morally or ethically correct, whether what was done was indeed the right thing. We may tell ourselves that nobody will ever know what occurred in the mediation. After all, there are non-disclosure agreements, right? And yet, if we understand the sociology of organizations, we know that really there are very few secrets. What was done or said supposedly in private or in confidence often leaks out. And sadly, it's usually in a bastardized form that may be a monstrous misrepresentation of what took place. So why does subjective perception matter? Well, because these are the everyday fibers of an organizational culture. What happens outside the formal meetings, that accidental bumping into somebody in the hallway, sharing a cup of coffee because a table is open in the cafe. These form the mortar for building relationships that can further the goals of the organization. Building a culture of trust in the organization can even lead to better cybersecurity and audit compliance. The other part of my functions as a corporate director, in addition to being chair of the Human Resources Committee during a major transition in our organization where we tripled in size. Now, why be concerned about it now? Because increasingly the modern workplace is no longer within a unified building or campus. Many individuals, even after COVID, are going to continue to work by remote. And many employees are no longer salaried employees. They are contractors working on basically piecework. And I don't mean here P-A-C-E, I mean P-I-E-C-E. It's a gig. And by definition, then, they're not really intended, or at least it may feel as if they are not really intended to be one of us, the organization. Next slide, please. Yeah. So when we put into the hands of the mediator the need to keep an eye out for the subjective experience of justice, that's a little scary, frankly. These questions are not questions, frankly, that ever occur to me as a mediator, not so much from fear, but from respect for the ethics rules that we were in the process still of developing then. They arose from my being a corporate director for 16 years in a high-tech industry. When I was interviewed, I remember somebody asking me about my experiences, and then they had said to me, "You know what, Phyllis? It's different though when you have the responsibility. You're not just advising somebody else. The buck stops with you." Boy, that was an insightful bit of observation there. because it turned out to be very true. And what I saw when I was one of those people with whom the buck stopped, if there's a lawsuit, that's, my name starts with B. Hey, I'm the first one up. It wasn't the same as in the position that many of you are in. When I was outside counsel, it wasn't the same. When I was a federal and state adjudicator, an administrative judge, not the same. Supervising a court-connected mediation program, not the same. And being the one who designs an ADR system, actually, what ended up happening in that process was something that illuminated this whole connection between designing a culturally appropriate and suitable and a system that can be owned by the people. That really did start me thinking about what we do here. Sorry, next, please. Thank you. Yes, for a decade there, I was going back and forth between conflict zones in Africa and then sometimes directly into a corporate meeting. So, what was happening in Liberia was heavily on my mind. And then all of a sudden we're talking about expanding the electric power grid. But you start to see some similarities in how these overlap. And then came this book by Seth Godin, Tribes in the Workplace. And oh my goodness, that book took off. I think maybe especially amongst high-tech folk who frankly are very much like me. We're nerds. We are introverts. We are people who probably never really felt like we fit in until somebody wrote a book that explained the dynamics. And boy, after that, people felt like they could body surf that wave. Next slide, please. Yeah. My work with Native American tribes through our Core Connected Mediation program, which we ended up calling Tribal Peacemaking, Oklahoma style, and rule of law projects for the ABA and State Department in Africa, and my own awareness of my culture growing up. Well, I would hear the word tribe in the workplace a bit differently than others would. Well, all tribes on both sides of the two columns here offer a sense of purpose, a normative structure. They offer mutual uplift. Now, among, how can I put this? Well, for lack of a better word, real tribes. These norms, values, and customs are rooted in deep collective memory. Furthermore, that collective memory is passed from generation to generation through stories and rituals that also look to what will happen to future generations. And no, it's not equivalent when American workplace tribes go out together for drinks after work. That might be a ritual, but it's not for the same purpose. Next slide, please. Okay, so when a corporate director or a member of the C-suite hears the enthusiastic embrace of tribes at work, they may end up asking some existential questions, namely, how strong is our overall organizational culture compared with the tribe? Because from the corporate director or C-suite perspective, tribe may actually be a silo, maybe a sectioning off of portions of the organization so that they don't share information, they don't work nicely together. Are the organization's norms, values, customs as clear and accepted as they understand and follow the norms, the values, the customs of their little tribe? Again, this is not a lightweight inquiry. It really does matter. If you recall on the previous slide, cybersecurity experts and experts in regulatory compliance recognize that an organization's greatest risk is that their people have not inculcated the day-to-day practices that are needed for security and compliance. If there is not a culture of compliance, then people are going to do things that, frankly, they shouldn't, and they don't even realize it at the time. They're just being friendly. Not a culture of security. Again, think about things like our standard security rules. In a secured area, nobody passes through that gate without scanning their own ID. No, you don't hold the door open for other people because that's the polite thing to do. No, you let that door close, and they have to open it themselves. How does that culture get built in? Well, yeah, I know that these practices are probably in a body of rules that probably are sitting in a file somewhere that's largely unopened ever. It might be in a software program that checks the box. But objective measures of good orders depend upon subjective trust in the organization. Otherwise, people do workarounds. Next slide, please. So, if you want to talk about where did all of these weird ideas come from, or should I say, new perspectives come from? Well, the three columns on this table lay out the highlights of a very long journey from mediating Indian Child Welfare Act cases involving transracial adoptions to ABA rule of law projects in conflict zones of Africa. With each iteration, we learned more about what I actually prefer to call relationship-based justice. And of course, in the middle column, being a traditionally oriented person, I needed to check with my elders to see if I was on the right track, if what I was doing was appropriate. I'm so grateful for the encouragement that I got from Dr. Vine Deloria and Dean Renard Strickland, two of the founders of the American Indian Law movement and the entire field of American Indian, Native American law. And a lovely little kind of benediction from Justice Sandra Day O'Connor when she visited us. Now we can return to this slide and what happened there if time permits. If not, please do visit my archival website, phyllisbernard.com. You should be able to download my articles that analyze lessons learned within the context of scholarly ADR literature. Next slide, please. Okay. Now, I have to apologize for the grainy photos. Now, some 20 years ago, we didn't understand pixels the way that we do today. But FIDA is the Federación Internacional de Abogadas. Justice Sonia Sotomayor is a member. I'm an honorary member. The women in this photo are solicitors, barristers. There's one minister of justice in there, and another woman, actually the second from the right, who later went on to become a justice on the Court of the African Union. Many of these women have advanced degrees in the law from Cambridge or Oxford. And here they are in traditional attire. Next slide, please. Ah, this was a moving photograph for me. It's a gift that they gave me because it meant so much to me to see other daughters of Africa in the robes of the court. Um, More particularly, it was a great honor for me to be able to see these women in action in our workshops, working with village women who had traveled so many miles through so many dangers in order to be there to learn how to help bring peace to their villages. They took the abstract legal theories developed about ADR and justice and literally translated them into pidgin, which is the language of the masses. And they forged an actual, nearly tangible bridge between law and culture. Next slide, please. Now, once or twice along the journey, somebody in the American legal education structure who did not know me and I sometimes think did not seek to know me, tried to dismiss this work as honestly just another white girl who's trying to do dances with wolves or something like that. They had just looked at my resume. They did not look at my picture. Well, here's the rest of the story. This is me wearing a head wrap that is an Igbo matron's crown. And the coral necklace indicates that I am Eze Nwanyi, a female elder of the village. Oh, and if you're wondering how to pronounce my Igbo name, it's Ifenyun Chukwu, and it does mean all things are possible with God. Next slide, please. Yeah. What did we do with these feed a village peacemaker methods? We negotiated with people like this young man in the photograph. He's an Ijaw warrior. Many people might instead call him simply a guerrilla or a terrorist. And his body is painted with magical symbols that are intended to deflect bullets. Okay. And so this is the level of conflict that we were working with. Not head on first. We went at it a step at a time, a bit at a time, until eventually FIDA was able to contribute massively to bringing a truce that lasted for 10 years in this area. So I gotta say, when I would go back and forth between conflict zones in Africa and what people thought of as conflict zones in corporate America, I thought, really? Really? Okay. Until you guys come painted with magical symbols that are intended to deflect bullets, it's a little hard for me to think we can't get to where we need to be. Next slide, please. Now, one of the things is, though, probably the mediator needed to have been brought in much sooner in the cycle of conflict, not when there was finally a case that was at the point of litigation or being litigated, but before we get to that point. Mediation really does seem to be ideal for the people problems that present to the lawyer as if they are legal problems, but they don't have to be legal problems if we get involved earlier rather than later. So with this one, these last slides, we come back full circle to where we began in our talk. These slides will show a few pivots that can help mediators to add value through their professional services. And here we ask for the mediator not to be biased or partial, just to exercise something more than total neutrality on matters that implicate established codes of conduct and industry standards. Next slide, please. These pivots do not invite the mediator to substitute their own sense of right and wrong, but rather to use a principled negotiation approach, recognizing that those who are affected by what they do extend far beyond the bargaining table. Now, there are many different approaches to mediation and to mediation training. The more or less standard approach concerning the issues raised here is simply to ignore them. Norms as a reflection of what is the right thing to do usually are not considered within the purview of the mediator. If the parties choose to raise these issues, fine, but the mediator will not. I think it's probably not grossly unfair to say that many people perceive the rules of mediation as being so neutral that just about anything goes, so long as the parties agree to it. Even if something happens there, if the negotiation involves doing something that may be unpalatable or unfair or seem to be so to other people who are not necessarily there in the room. Now, the backbone of tribal peacemaking is principled negotiation, where shared, accepted, or required standards will canalize bargaining. Parties might vary a standard deviation to the right or to the left, but they do not leave the zone of doing what is right. Next slide, please. Okay. Now, the very words "do the right thing" automatically raises concern and objections. Right according to whom? The mediator? No. It is not a personal judgment by the mediator. It is the mediator preparing in advance, preferably with the party attorneys, to identify relevant provisions of the organizational code of conduct or industry standards. When it's unclear what direction to turn toward the code or standards. What if there are no provisions that apply? Or perhaps the organizational guidance that's offered is itself part of the problem. Well, the right path might be to consult with the parties themselves to articulate their own priorities and values pertaining to this conflict. In Nigeria, we were able to reduce generations of communal warfare through exercises that help disputants to identify what mattered most. Ultimately, that principle to guide negotiations became no parent should have to bury their child. Next slide, please. So, do you remember this photo from the beginning? You have a young woman in the foreground, while in the background, two colleagues are engaged in a tete-a-tete with each other. A fairly classic representation of the office grapevine, yeah? It is easy to dismiss the grapevine as mere gossip, not worthy of consideration, especially not worthy of a mediator's concern. On the other hand, this informal, unofficial transmission of what people think they know can wield far more influence than what actually occurred in a mediation. A conflict that is built over time draws to it other members of the clan or tribe who serve as constituencies. More than mere entertainment, others can feel deeply invested in how they see justice having been done or injustice. These are the ripple effects, the unintended consequences of proceedings under a seal of confidentiality. because the reality is constituencies will prod the parties, poking at them. They won't be satisfied with a no comment or I can't say, it's all confidential. Just as nature abhors a vacuum, the grapevine will begin to hum with versions to fit their agendas, whatever that agenda might be. So tribal peacemaking recognizes that others have a genuine interest in how conflicts are resolved, using the mediation to craft a message agreed upon by all, something that can be shared with others, is a way to help reduce, to fill somewhat that vacuum. Of course, that message that is shared with others does not disclose details that really must remain confidential. Last slide, please. So, as I had said, mediation may be the optimal way to resolve people problems that present to the lawyer as legal problems. But the law is only part of the resolution. A relationship-based justice honors this truth. It is summarized so well in a saying from the Niger Delta that was introduced to me back in 1998 when they first started working on getting me to come over. What touches one, touches all. And I guess the American corollary would be, we're all in this together, for better or worse. So thank you for your time and attention. I look forward to your questions and comments. You're going to help me to see from new perspectives. Thank you very much.
Phyllis, that was terrific. Thank you. And I know we're going to have some questions. People can either raise their hand and we'll call on them, or they can post them in the chat and Jean and I will take a look at them and read them for people. Phyllis, let me start with a question for you, which is that sometimes we get into a mediation and everybody's from a different tribe. You may have, in a typical employment case, you may have the plaintiff's lawyer who's part of the tribe of plaintiff's lawyers, and you may have an employee from a large organization, and they may gather at a particular church or a particular bar or a particular coffee house, or their kids may all go to the same school, and that's part of a different tribe. And then on the defense side, you have a lawyer who's part of a completely different tribe within the bar, the defense bar. You may have a corporation as a defendant that is part of an industry or trade group. So when you have all these different tribes showing up that may have different standards or different cultures, how might a mediator approach developing a common set of norms in the context of which we can negotiate?
What we have found to be helpful anytime that we're doing principled negotiation, our tribal peacemaking Oklahoma style model was so successful that it expanded to churches that were on the verge of splitting up or had already filed to break up. It extended to community conflicts, and everybody has a different agenda there. When faced with conflicting, possibly, codes of conduct and industry standards and interests, this is a time for the mediator to be able to spend additional time in preparation, sitting down with these various tribes and working through the standards, the principles that they're going to use in negotiation together. Not necessarily for the mediator to decide, but for everybody to get together to decide which one of these principles, how will we express these principles to be used in our bargaining here at this time.
So what do the questions look like in those preparatory calls, and how does a mediator help people get beyond a plaintiff's lawyer who simply says, listen, I'm here to raise as much money as I can for my client, and me. And the defense lawyer says, I'm here to get my client out of here for as little money as reasonably possible so that I get more business down the road. And how do we get beyond just the distributive bargaining elements of things?
That is a tougher one because you're talking about people who see a very real, immediate money interest, self-interest, and continuing to do things the way that they've always done things. I would like to believe that increasingly, though, we see the people who hire them, especially the organizational entities that hire counsel, to be looking to what impact is this going to have within my organization? And I am looking to, and this is where the board of directors comes in. Our job is not to oversee the day-to-day in and out of the organization, but it is to be looking down the road to see what is reasonably foreseeable longer term, past this quarter. What's reasonably foreseeable in the next 2, 3, 4, 10, 20 years. And I would suggest that the trajectory that many of us are on does not necessarily bode well. I would also suggest that there is a very good possibility that we are experiencing some generational changes within our various organizations. At the risk of overgeneralizing, because I know individuals will be individuals. But when one looks at the zeitgeist, the character of a generation, we baby boomers might be more inclined to suck it up and soldier on. As an employee who believes what they're seeing in their workplace, in their organization, what's being said to the public does not match up with what they see happen day in and day out. Millennials and younger, they're not going to tolerate it. They are not going to stay silent and still support the organization above everything else. They will leave. It might be a very noisy withdrawal, as we saw recently with Facebook.
So in cases, Phyllis, that don't get to the level of board attention, and my sense is that relatively few cases in an organization of any size are going to be of that type. You're talking to a lawyer from an outside law firm. Typically, you may have some access before mediation to an in-house lawyer or claims person from an insurance company. You oftentimes don't have access to the actual clients before the mediation. What is a mediator to do practically in order to set the groundwork for a productive day of mediation?
I think first the mediator has to see their role as being more than just that day of mediation, but rather to sit down with the attorneys in advance and start to get some sense of what the objectives may be, and but more than that, what are the borders, how to canalize, how to decide, this is what we will be negotiating according to, these will be our rules of engagement.
Mhm.
Now, I don't mean to automatically suggest that there need to be more lawyers hired, but I think there need to be more lawyers hired in-house, because it is the in-house counsel, that in-house legal department that ultimately has responsibility, well, not even ultimate, immediately has responsibility for the issues of compliance, including compliance with regulatory standards for the industry immediately. They have to deal with the employee disputes and dissent and the failure of silos within the organization to talk with each other. That's an immediate operational issue. There is a mutual cause within the organization administrative structure. There's a shared cause of concern to make sure that there is some consistency. and also to make sure that employees know this.
Can you think of a specific example, Phyllis, of how this might play out in practice?
Again, I focused especially on bringing the mediator in earlier in the process before you actually have a legal case filed. Actually, in an article that I wrote for Ohio State University's Dispute Resolution Journal some years ago, it was my vision of what lawyering in the 21st century would be. And it's already starting to come to be that there would be fewer and fewer litigators defining what it means to be a lawyer. But instead, the greater need and the growing need would be the lawyer who is able to be that bridge between different cultures and different nations in different sections of a business. The example I used there, should I say it? I think I can. Okay. It was actually based on a case concerning a major pharmaceutical company. Yeah, I won't say their name. A major pharmaceutical company, and I turned that into an ongoing example of a dispute that arose because of cultural miscues in communication between an employee and a vendor. And particularly because the vendor happened to be Latino. Racial discrimination issues were triggered that might not otherwise have been. I'm not sure that that was necessarily in the mind of the employee in that particular company at that time, but the perception definitely came to be there. And it did not take long before this ended up being literally a federal case. And I show in that article, step by step, how the intervention from a mediator, basically somebody who's like an ombudsman within the organization or somebody that can be turned to in that capacity, could have intervened. It ends up being a design for a multi-tiered dispute conflict prevention and resolution system. Because if the ombuds approach doesn't work, then it may be necessary to go to the mediation. It may be necessary to go to arbitration.
Okay, let's open it up, and I hope other people have questions as well. And in response to this very stimulating presentation from Phyllis, if anybody would like simply to unmute themselves, or if you're more comfortable posting a question in the chat, please go ahead. Jean, any thoughts, questions from you?
Well, yes, I'd be happy to. What a fascinating presentation. I took a lot of scribbled notes here on the back of the paper, when I was in practice, I was known to have napkins and other things staple or put into case files at times, just whenever these thoughts hit me. I really love this, what touches one touches all, that you said. And that is so true. Do you have any special thoughts or hints on ways, practical ways, when you are in a mediation in civil litigation, where people are so angry with each other, they may be coming through the computer screen at you on a Zoom, whatever it might be, to be able to convey that in a way that can make a difference?
Let me go back again to the need for broader and deeper preparation than what is standard. I think mediators need to demand some time to say, in order to get an outcome that will help you short-term and long-term, we need to spend some time trying to understand what's going on. Now, you may do it with your client yourself. You and I can do it, or we can do it right there in the meeting. That, of course, might be a little fraught because oftentimes lawyers themselves haven't taken the time to really understand what their client is concerned about. So many times what they're really concerned about is financial. It's about security on both sides. Because if a supervisor ends up in a litigation posture against one of the people that they are supervising, that's not a good thing on the supervisor's record. Obviously, if somebody has a claim against their employer, there's a really strong possibility they will end up being blackballed. So survival is an issue that oftentimes we don't just lay on the table. And I think that maybe we do. Part of that want to leap through the screen kind of concern comes from actually fear that they're going to lose their ability to provide for themselves and for their family. I think mediators need to be ready to touch the wound so that it can be healed. That's another one of the phrases that I was introduced to back in 1998 when FIDA was visiting us. We got many visitors through the U.S. State Department because Oklahoma has a viable legal system of federal, state, county, local, and tribal law. And so we're a really good place for delegations from Africa to come and sit down and talk with us. And that was one of the things that was said as I talked about who we are and what we do. They said, if you cannot touch the wound, you cannot heal it. And Jean, I think that that applies also for us here. You have to be ready to risk understanding the fear behind that rage.
That's fantastic. I agree with that. I can picture it in so many situations. So I wrote that down now too. So
Yay.
All right.
Now, Jean, if I may offer, there really is a deeply personal element to all of this, specifically the work in Nigeria, because I don't know, you might be too young to remember the Biafra War.
No, I remember we used to raise money in school, you know, for the hungry children and starving children in Biafra. Mm-hmm.
It was my late husband who was the photojournalist who broke that story.
Oh, wow.
Starving children of the Biafra War. And he later lost his life because of vectors that he picked up while he was there. And my people, the Igbo, they wiped out 1 million of us through the starvation. Now, again, it may be necessary to negotiate amongst the third-party neutrals and the attorneys and all, because everybody who was involved in the core of our training were on the side that started the blockade, that starved out 1 million of my people. And we had our own issues that arose from time to time. And we needed to have some mediations amongst ourselves. So I'm not suggesting that this is easy, especially when you touch a person's sense of survival, whether it's their dignity, whether it is their sense of commitment to the people who made them who they are, whether it's their fears about the future for their children and other people's children. None of this is easy.
Well, if it were so easy, everybody would do it, right? And
exactly.
I feel like it's a calling. We are called to do that. You know, there is on that same general topic here, there's a question I just received. What advice would you give our leaders on how to heal the divisions we see in the USA? And we're at 5 minutes till 9.
Okay.
That's every time.
Yeah. I want to believe that we are not a lost cause. It is very difficult sometimes because I'm looking at the whole system. I'm looking what's happening at the state level and the local level, not just at the national level. But it has to begin with principles founded in the Constitution of the United States. I think a whole lot of the troubles that we are seeing is because civics, basic government, is no longer taught in schools. It hasn't been taught in a generation. It is not part of the core curriculum. So people honestly don't know how an election is supposed to work. And so they'll believe anything that somebody tells them.
Okay.
Okay, we're coming up to the end of the hour. We usually talk at the beginning of the hour about the running total of how much money has been contributed by our generous audiences to food banks so far. Today, Jean, why don't we end on that high note? And if you could report to us on how much we've raised through the end of 2021 and the number with which we're starting for 2022. And I know that the people on the line are going to be moved to contribute to the Port Angeles Food Bank. The link is in the comments, or other food banks that are important to them. Jean, could you please give us the report?
Sure. And this really ties in. You were just talking about the starving children of Biafra, and here we've got so much starvation all around the world. Thank you for everyone for your generosity. At the end of 2021, we were at about 217, 218, as in 100,000. 218,000, 217,000, somewhere in that number. Natalie isn't here. She's on a well-deserved holiday with her family in the US, so we don't have the exact number, but clearly we're looking at approximately $220,000 raised that we know of. That doesn't include money people have just donated by being moved by these things in the Will Work for Food program and haven't told us about. So the generosity is outstanding. We're coming up on $250,000. That's $2 to $3 million, or 2 to 3 million meals. And thank you so much. Please feel free to let Natalie or any of us know the amount of a contribution if you're so inclined, and we'd be thrilled to add it to the total. So thank you, and thank you, Phyllis. I'm sure we will increase that number greatly after your presentation today.
Yeah, I'm confident of it as well. Thank you for the report, Jean. Thank you, Phyllis, for an absolutely incredible presentation. Thanks to our generous audiences for being here and listening and being so generous to contribute to food banks, Port Angeles Food Bank, and food banks all around the world. It's been a great morning, a great start to 2022 for the Will Work for Food project, the New Possibilities Hour. Sarah Agamiri, thank you so much. Jean Lawler, thank you. Phyllis, thank you so much for an incredible presentation. And with that, my friends, we are complete.